This is attorney Ahmad Yakzan from the American Dream Law Office. Thank you so much for joining the American Dream team with this session of Ask Ahmad. We are live right now with you. I would love to have some questions. We do have some things that are already submitted from our people, so I will answer them. I would be more than happy to answer any questions that you guys, if you send me any comments, I would really appreciate it. I do have a couple of things to announce. As of yesterday, we have been in business for 5 years now, and I wanted to thank everybody who has made this possible. You guys have really entrusted us for the past 5 years, and we're looking forward to the next 50 years of helping our clients. Honestly, we would not have survived without all the referrals that we get from our attorney friends that know the service that we provide here at the American Dream Law Office. I love you all. I would really love it if you can go to our pages and like them, our Facebook, Instagram, and YouTube. We need the YouTube followers. We just started posting those videos on YouTube a couple of months ago, and as some of you might know, we need 100 followers on YouTube to get that vanity American Dream Law Office URL. So if you could please just go on YouTube and like us, and if you can like us on Facebook, if you're watching and you haven't done the Facebook likes or the Instagram follows, I would really appreciate it. This is a very important announcement. We only have like 6 days left on the 2020 promotion for naturalization cases. It ends at the end of June. So if you are planning to apply for naturalization before the end of that promotion, please give us a call. You know the number is 1-888-96-DREAM. That's 1-888-963-7326. And I did speak about it in last month's video. We do have a couple of videos on the website. So that includes applying for the applications, going with you. If you live here in the Tampa Bay area, we go with you to the interview, preparing the forms, doing all of that stuff for 2020, $2,020. Again, that doesn't include any filing fees, and you would not actually be able to take advantage of that if you have some criminal issues or things like that will complicate the case. I promise, even if you do have some of those issues, I will take care of you, we'll give you a discount. And the only reason why I'm doing this is for you to be able to vote in 2020, hopefully, if everything goes okay. On processing times, I know COVID closed USCIS offices for a while, so what we're trying to do is move cases forward. However, because of the backlog for the 3 months, naturalization cases are not being scheduled as quickly as they used to. So before COVID, things were moving quickly. If you do it online, we were getting interviews within 3 to 4 months. So now I really honestly don't know when we're going to be getting them, probably at the end of July, beginning of August. But again, the people whose interviews got postponed get priority over people who actually apply anew. So they are still processing the cases, they're still adjudicating cases in Tampa and in USCIS offices. However, they are taking longer than usual, and the processing times are really, really bad right now. So if you qualify for naturalization, or if you want to apply for any benefit, we haven't missed a beat here at the American Dream Law Office. So we send in cases, we worked through COVID, we did all of that stuff, and as I said, we were actually set up to go remotely from day one, so we will be able to do all of that stuff. If you need to apply for anything, please call us. Again, the number is 888-96-DREAM. One thing that we came up with, July 4th is coming up, and America is celebrating this 244th birthday. We turned 244, and it's been 244 years since 1776 when we declared our independence. So what we're doing is we are doing 15-minute consultations over the phone for $76. Um, give us a call if you want to speak to me, and I'll be more than happy to do that. So again, and I know I keep saying the number is 888-96-DREAM. We have those, as I said, those videos are going to be done every month. So call us or email us all those questions that you have for next month video. It's the last Thursday of the month. We'll be able to do these every single month. And with comments, send us anything that you have, questions, anything that you have about immigration, please send them to us. The email is reem, which is REEM, at AmericanDreamLawOffice.com. So today we have several questions. I know immigration has been a hot issue in the last couple of weeks. The Supreme Court issued a couple of decisions about DACA, and yesterday they issued a decision about indefinite detention for asylum. I have not read the one about the indefinite detention, about the habeas petitions for people who are applying for asylum and they are detained. So I'm probably gonna post a blog post about it, but I can talk about the DACA decision for a couple of seconds. One of the questions that we got: how would the DACA decision actually affect me if I had DACA before? And what I've been telling clients is that if you had DACA before, even though the case was before the Supreme Court, you should have actually applied for renewal. But we have a lot of clients who qualify for other type of relief. So if you have DACA and you've been here for a very long time, and there is an immigrant petition that was filed on your behalf, sometimes you're able to actually apply for that permanent residence or some sort of fiancé visa or anything, something that would actually give you a better status than DACA. We represent a lot of people right now who are on DACA, and they had immigrant petitions that were pending before, when they were 2 or 3 years old, and now they come to us. I'm on DACA, it was going to be taken away, so we applied for their permanent residence, and we were successful in getting their permanent residence and moving them away from DACA. This is my disclaimer in every single video. Please understand that these actually, I know I'm talking about previous cases and results in previous cases. So if you have a similar case, none of these things in these video apply to you. Please don't take it as legal advice. We will have to talk to you about your individual case before I actually do anything. So please let us know. If you have DACA, call us. We'll help you renew your DACA if you've gotten it before, and we will look for other options for you. I'm gonna run very quickly through the Supreme Court's decision, and honestly it's a very technical decision that a lot of non-lawyers will probably not understand, but I'm going to try to sum it up in a couple of sentences. The Supreme Court did not rule on the legality of the DACA program. The Supreme Court said that the Trump administration tried to take away DACA in the wrong way. So basically for now, the DACA program is in force. You can apply. I don't know if immigration is going to be processing these petitions, because what they said, they issued a statement after the Supreme Court decision, and they said, okay, we still believe DACA is illegal or unconstitutional, but we will abide as much as we can abide with the Supreme Court decision. So among immigration practitioners, we're asking ourselves, what does that mean? What's going to happen? So, but the safest thing right now, I know it's a hit, apply for your DACA renewal. At least that puts you in the queue to see how they're going to adjudicate those petitions down the road. Again, a lot of our DACA people, our clients, have actually been able to get permanent resident status in a different way. So if you have DACA, call an immigration attorney, speak about the renewal, and talk to them about whether you qualify for a different sort of relief in immigration for you to actually have a more permanent status I do have a blog post on our page that talks about 4 different things that you can use if you are a DACA recipient, and 4 benefits that you might not even know that you actually qualify for. It's on the website americandreamlawoffice.com/blog. It's maybe from last year, but if you do a search for DACA alternatives on the website, you'll be able to actually look at those. But call us, please let us know if we can help with anything. The DACA, again, as I said, the DACA program is still in power. Go ahead and apply, but we really don't know how USCIS is going to interpret the decision. It did say that we're not ruling on the constitutionality of the DACA program. We're just ruling that they actually tried to take it away in violation of the Administrative Procedures Act, which really regulates how USCIS and any administrative agency can put things together or take things away, any benefits away. So it applies to all administrative agencies. We do have a question about the presidential proclamations that have happened in the last couple of weeks. President Trump did have a proclamation regarding coming in for a green card. I think last month, and then yesterday he suspended through proclamation the entry of business visa holders, J, H1, H1B, and L visas from coming to the United States. So one note that we have to talk about is that the proclamation yesterday does not stop all visas to the United States. It does say that if you're coming here to work in a healthcare field, you probably will be able to come into the United States. But let's run through them. The proclamation from last month suspended people from coming in because of the high unemployment rate. Honestly, I believe that the president is using immigrants as a scapegoat again. I know that we have high unemployment, but a lot of the people who are affected, most of them in the healthcare industry, asked the Trump administration not to stop people on those visas to come in on those green cards, especially if they are healthcare workers. So we have a lot of people who are healthcare workers who are helping with COVID-19. So there was an exception for the proclamation from last month from people who work in the healthcare industry from coming to the United States under a green card that is attached, an employment-based green card that had to actually do with people who work in healthcare. So there is an exception for them. Really, the exemptions are very, very high, so it might not even apply to you. But what the proclamation from last month said, okay, we have a lot of people who are coming here on I-140s, which is a petition that you use for an employment-based green card, so I'm going to suspend that for people not to come here and take jobs from United States citizens. The issue that I have is when you are doing an I-140, depending on which category you actually use to apply for that visa petition, a lot of times you actually have to prove that a lot of people who are, if you apply for the I-140, you do have to go through a labor certification period where you have to advertise to the whole world, or at least people in your vicinity, that you are applying for a green card based on employment for your employee, and that employee has to prove that no one else can actually do his job. So a lot of the I-140s, especially under the second preference, which the majority of people apply under the second preference out of the 5 preferences. The second preference people, most of them actually have to go through the labor certification period, where you have to prove that there are no American citizens that are able to take your job. So suspending entry of these I-140 holders or those green card holders based on employment just does not make sense. That's number one. Number two, if you read the proclamation, actually both proclamations, the one from yesterday and the proclamation from last month, it has a lot of equal protection and due process problems. And what we see is that once the Trump administration announces by proclamation or executive order that they are suspending immigration, they're not following the law in those suspensions. So applying what the Supreme Court did in the DACA decision, for example. In the DACA decision, they said no one says that the president cannot actually stop some immigrants from coming to the United States. However, you have to do it a certain way, and the reason that you give is very important. So in that decision to actually stop DACA, the CIS director said, okay, well, Attorney General Sessions says it's unconstitutional, then I'm gonna just go ahead and just suspend everything. And the Supreme Court said, no. As an administrative agency, you do have an independent way of actually making your determination. You don't have to go by what the Attorney General said. You have to make your own independent determination of whether something is constitutional or not. So what I see happening, and I think the one from last month, we did have a couple of court challenges to it, and actually one of them we won an injunction against. I think Ayla filed for an injunction against the administration, and there is a nationwide injunction against them. The one from yesterday, we really don't know because it just happened this week. But we're going to, immigration lawyers around the country are going to court and saying, you violated the Administrative Procedures Act. You really cannot do that. So what I can see from a lot of from the proclamations is they do have a lot of constitutional problems, and I think that they are going to be challenged in court. So, having said that, what does the proclamation from last month do? It stops people, as I said, from coming in on green cards for work. That's number one. It stops other people from coming in if they are coming in from a petition from a lawful permanent resident. So if your spouse in the United States as a green card holder, we are going to suspend the processing of that green card for them to come to the United States. It also stopped, as I said, it exempted a lot of the healthcare workers from coming in, and I think that's where the equal protection grounds, the challenges that might come to that proclamation might come from, because you're exempting some and not exempting others. Another problem that you have is that he's not suspending it for national emergency or anything like that. They do try to coach it in a national emergency sort of reasoning, but there is a problem with that because there is a shortage of healthcare workers in the United States. So again, there are a lot of things that are going to have those proclamations are a lot of constitutional problems that they're going to have, and I think I think there's going to be a successful challenge to that. The one from yesterday, again, as I said, it applies to only 3 kinds of visas. That's the L1 visa, the H1B visa, and the J visa. But also there are exemptions for healthcare workers there. That's number 1. Number 2, the proclamation from last month doesn't apply to any people who already had green cards. So if you have a green card already, you can come to the United States. They cannot stop you from coming in, and it also does not apply to spouses of United States citizens. So if you're a green card holder, for example, you applied for a spouse and you're eligible for naturalization, what we can do is apply for citizenship, and hopefully, it would get done soon, and then you will go ahead and elevate the preference on those, and you will be able to come in. Notice from the one from yesterday, it did not include the e-visa, for example. And in our office, we do a lot of e-visa work for people from the 46 countries that are included in that category. So if you have an e-visa, that doesn't apply to you. It only applies to those 3 visas in the proclamation. So if you are from Jordan, for example, or if you're from a country that has an actual treaty with the United States, the president did not stop those. So if you have an e-visa, or if you want to come in and you have a B1, B2 visa and you want to come into the United States, that means that this is one trick that you might be able to use. I have clients who have B1, B2 visas. They can come in on that visa, but you can have two visas on your passport in the United States. You can come in under the B1, B2, but you will be limited in running the company and all of that stuff. But if you actually have a B1, B2 visa and have not applied for any of those three visas that I just mentioned, you can come to the United States and we can change your status here in the United States. So the proclamation from yesterday doesn't apply to people who are in the United States. So if you are here on a B1, B2 visa and you want to apply for an L1 visa or a J visa by a change of status or an H1B, then we will be able to apply for that. And I think this is where the equal protection argument might come from, because you're actually having two disparate classes here. You're treating people outside the United States differently from people who are here in the United States. So the question was about the proclamation from last month, and I just reread it. How does it affect I-130 petition, and what the executive order entails? I already spoke about what the proclamations entail. Would it affect the I-130 portion? I don't believe it will. Again, you have to understand that it applies to people who are outside the United States, not here. So the processing of the I-130 for a relative who's outside the United States would not stop, because USCIS is actually adjudicating the petitions here in the United States. But if your spouse is outside the United States, the issue that you're going to have is what is the National Visa Center is going to do once that I-130 gets approved. And I believe that because of that I-130 getting approved and sent to the National Visa Center, I think that is the portion that you will actually not be able to go through. So if you are a permanent resident and you're not eligible for naturalization, I think you should apply for the I-130 portion regardless, because that would give you the priority date today compared to waiting 3 or 4 months. That would actually make a whole lot of difference, that you should, when it comes to that visa availability. So you should go ahead and apply for the I-130. Another thing that I wanted to mention is that the proclamation from last month was only for 90 days, and it actually going to expire. So there is a sunset clause in those proclamations. So after 90 days it's going to stop. So we don't know if the administration is going to extend it or not. So that's just one point of caution. So if it doesn't get renewed, they have to start processing these petitions again. But the 90-day period is actually expiring. I believe it's in July next month. It will actually expire. So if you want to apply for a spouse, don't wait. Again, as I said, you can call us at 888-96-DREAM, and I'll be more than happy to speak to you about your options and how to talk to you about how the proclamation will actually apply to you, whether it will not, and how to apply for your spouse. The other question that we have is, can I apply for M400 90 days before completing 3 years of marriage and before having or receiving any decision on I-751? Again, we have a blog on that, and I have a video regarding that on AmericanDreamLawOffice.com/blog. I did post on that. So there's a couple of things that are happening. Let me explain a couple of things before we move forward. What is an I-751? If you are married to a United States citizen and you apply for a green card, actually, even if you're married to a lawful permanent resident, but this question kind of doesn't apply to you. But if you're married to a United States citizen for less than 2 years, and that United States citizen applies for your actual green card, you get a conditional permanent resident card. You don't get the full 10-year green card, and you will have to apply for removal of conditions within 90 days before the expiration of that card. So let's say your green card, your conditional permanent resident card, set an expiration date of September 2020. 90 days before that would be so September 25th, 2020. Today would be, June 25th, 2020. Then you can apply for that removal of conditions. So you have to do it 90 days before the expiration of the conditional resident card. The problem that we're having now is that these petitions are taking almost 2.5 years to process. So some of our clients actually become eligible for naturalization under the 3-year rule instead of the 5-year rule. And let me explain the difference between the 3 and the 5-year rule. The 3-year rule, if you've been married to a United States citizen for 3 years, you've been a permanent resident for 3 years, because the conditional permanent residence period actually applies to that. And you are your United States citizen spouse has been a United States citizen for more than 3 years, then you can apply under the 3-year rule instead of the 5-year rule for naturalization. So if you are actually, if you're under CPR, you have a conditional permanent resident card, and you apply for I-751, 90 days before that 3-year period ends, you can actually apply for your naturalization at the same time. So you can have the 751 and the N400 pending at the same time. And we've done that for a lot of our clients, that we'll apply for the N400 when they become eligible once the I-751 is pending, and then they will adjudicate both of those petitions at the same time. So we would go in, the officer will look at the I-751, adjudicate that, remove the conditions on permanent residence, and then in the same interview we'll be able to do the N400 interview for you, so they would adjudicate both of those petitions together, which absolutely would be fantastic, because it will take away some processing time from the I-751, and then you will become a citizen, which actually is the ultimate American dream, I believe. That would really help you. So yes, if you have a 751 and you're eligible to apply for the N400, let's go ahead and apply for both of them. And what we do is we do give discounts. If you, for example, you did a 751 with us, we will take some money off the naturalization for you, because we'll be using the same evidence for both. But call us, even if you haven't applied for the I-751 with us. Call us, and I'll be more than happy to speak to you about naturalizing while that 751 is pending. You don't have to wait the whole 2.5 years for the processing. The next question that we have is, I am a U.S. citizen and I want to apply for my brother. How long does the process take? In the United States, you can apply, if you're a U.S. citizen, you can apply for a bigger pool of people than if you're a permanent resident. Okay, so if you are a permanent resident, you can apply for unmarried children, you can apply for your spouse, you can apply for those categories, but you can't apply for your parents, for example. You cannot apply for your brothers and sisters. The problem is, if you are a permanent resident, you actually have to wait for the visa number to become available. But if you are a United States citizen, then the beneficiaries get classified in a different way. So if you are an immediate relative of a United States citizen, then you don't have to wait for that visa number. And those are children, spouses, and parents. So if you become a citizen and you want to apply for those 3 categories, you don't have to wait for the visa number to become available. Now, when it becomes tricky is when you're applying for your children who are over 21, if they're married or non-married. The categories will differ, and then you can apply for your brothers and sisters. Because you have to wait for the visa numbers, those can take a very long time for those visa numbers to become available. So for example, if you're a United States citizen and you're applying for a spouse, a brother or a sister from Lebanon, for example, right now is the wait time is about 14 years, and I know that's a very long time, and that's one of the reasons why Congress was trying to actually get rid of the brother petitions and use those visa petitions towards a different category. One of the things that you have to understand and why there is a backlog is because the United States Congress has a limitation on the number of visas for categories that can be used for that category. So if you look at the visa bulletin from the State Department, it will tell you which dates we're working on and which eligibility dates, those effective dates that you can actually use for you to apply. So once that day becomes available, then you can apply for your permanent residence or for your immigrant visa. For your, the beneficiary can start processing that. But because of the per country limitation and per category limitation, a lot of people are applying for those. United States citizens can apply for their brothers and sisters immediately after becoming citizens. So there is a backlog on those numbers. So there is not an available visa number for them to use to come to the United States with their spouses, for example. So that's why there is that wait time. So right now it's about 14 years. Something that we've done is if, for example, you're from an E2 visa country or an E visa country, we were able to bring you here. Sometimes they bring you here and wait for that green card application to be done. Another way is for them to come here on a student visa or a work visa or anything like that, and then wait for that processing to happen. And then once that number becomes available, they can apply for permanent residence if they haven't applied for permanent residence another way. So there are ways around it. You just have to call us, and again, the number is 888-96-DREAM. The last question that we have is, I applied for I-751 last September 2019. I did the fingerprint last January. How long does it take for the I-751 normally? And again, I kind of alluded to that earlier in my previous answer, is it's taken about 1.5 to 2.5 years. The 751 category, however, there are a couple of things that people don't understand. Is that even if you are a CPR, you're a permanent resident. So you have all of the rights of permanent residence when you're here on conditional permanent residence. So don't feel like you're inferior to other green card holders. So what will happen is that once you apply for the 751, immigration is cognizant of the fact that it's actually taken a long time for them to process these. So they send you a letter saying we're extending your status for 18 months, and then you can actually ask for another extension unless you become eligible for that naturalization in the other answer that I gave you. So you applied in September. I don't know which processing center you're under, or which in Tampa, for example, it's taken about 1.5 to 2 years, because that's the last one we did for a client. But if you're in a different district, it might actually differ. But if you're a conditional permanent resident, you still can actually work. You can leave the country and come back. You're a permanent resident. The only issue that you're gonna have is that you don't have a card. A note of caution, though, you do have to either file for a green card jointly to remove the conditions jointly with your U.S. citizen spouse, or if you're not with your spouse anymore, you have to go through an exception, and those exceptions are very tricky. So if you're doing a 751, at some point the rejection rate was about 65%. So you really want to hire an attorney to actually help you with the removal of conditions. Don't do it on your own, especially is that if you actually get denied the 751, under the statute you have to be put in removal proceedings, and it has to be referred to the immigration judge for you to remove your condition. So look on the website uscis.gov/processing times, and you can put in the form that you have and which district you're in and which processing center you're going to be under, and it would tell you what the processing time would be, and it would give you the date, because that last question gave us a date. So it would give you the date that district is actually working on. They do have a lot of online tools. For example, for the question about sisters and brothers, there's also a website from the State Department that will tell you which states they're actually working on. So make sure that you visit those two websites to be able, and I will post them in the comments in a second for you to be able to check for the people who asked us a question. Thank you very much for watching. I see that we had a lot of people watch. I would appreciate any questions. Email your questions to reem@americandreamlawoffice.com. For the next one, it's going to be the last Thursday of July. Happy July 4th. If I don't hear from you by then, I wish you and your family a safe July 4th. Happy birthday, America. Please social distance. If you're going to be outside, wear a mask. If you don't have a mask, stop by. We have extras. If you want to come into the office for a strategy session, we have extras for you. Even if you don't want, we would be more than happy to provide one for you. Again, we're not missing a beat. It's been 5 years, and I'm very excited about that. Unfortunately, because of COVID-19, we didn't have a celebration, but we're going to have one soon. Especially, I'm turning 40 later this year, so we'll probably have a joint celebration for both here at the office. Thank you so much. I appreciate you listening. Please call us 888-963-7326 or 888-96-DREAM. Give us a call. We have a chat tool on the website 24/7. You can send us any questions and you can get scheduled. Call us, like us, follow us on YouTube, please. Again, we need about 50 followers on the YouTube channel to get that vanity URL. I appreciate you. Thank you so much, and until next time.